I'd like to reserve 5 minutes for rebuttal, please. We are appealing a summary judgment in this insurance bad faith case, determining that Mr. Vachon's civil remedy notice failed to comply with the specificity requirements of Section 624.155. And we're asking the court to do two things. First, to confirm the test for compliance with statute, and we're calling it substantial compliance. Basically, if it informs the insurer of what the alleged violation is and how it can be cured. And the second thing we're asking this court to do is to address the waiver and whether, when an insurer responds on the merits to a civil remedies notice without raising any issue about compliance or specificity of the notice, whether it can later raise those alleged defects in the litigation.
And I don't want to mess up your flow, Ms. Gunn, but I'm about to.
You're my flow.
Okay. Jumping to the waiver argument.
Sure.
I looked through the judge's order, and I didn't find any case that directly said that this kind of issue cannot be waived or subject to estoppel. Right? I looked at some reasoning based in part, or in large part, on a concurring opinion in another court and a citation PCA from this court, and that's it, correct?
Correct, Your Honor. Yeah, I mean,
so the fourth DCA cases, the fourth DCA seems to have a lot of cases that says this is waivable.
Mm-hmm.
Would that be binding on the judge if the judge can somehow reason his way, relying on a concurring opinion in another court and a citation PCA?
Absolutely, Your Honor. Pardo versus State, right? It's these fourth DCA decisions are binding throughout the state. Obviously, this court has an opportunity, and we are requesting that to reaffirm that is the law in this district as well. But we have, starting with Evergreen Lakes and the Owens case and the Neal case and the Bay case, repeated discussions from the fourth DCA about the fact that if you really have a specificity problem or a compliance problem with the civil remedies notice and you respond on the merits without raising that, it's waived.
Okay, so I didn't miss anything there.
No, Your Honor. I mean,
and on the other hand, there's no other decision outside the fourth DCA on this topic, is there?
Well, Your Honor, the ping pong case, which is
talking about state court, but I get that was Judge Brooks,
right? And this relates again to the strict versus substantial compliance issue, and the fact that a lot of them are federal court cases. I mean, the law does develop in this area in federal court with some frequency because a lot of the cases get removed, right? So it would be our position that we can't just ignore federal court cases, but. Yes, Your Honor, the law on waiver and estoppel has really developed in this specific context in the fourth district. But again, we have general cases from the Florida Supreme Court, from this court, saying that statutory notice requirements can be waived. You can be stopped from asserting statutory notice requirements. And we have relied, on both of those in this case. It really, the waiver rule that we're proposing that the fourth district has adopted makes a lot of sense in this context, because if an insurer can respond on the merits to a civil remedies notice, if it's specific enough to allow you to consider it, to roundtable it, to file a response that says, this is what happened in this case, this is why we think we're right, this is why we think we're wrong, we decline the opportunity to cure. The intent of the notice requirement is to provide that opportunity to cure, potentially avoid a bad faith case if, it's like a safe harbor opportunity. Requiring the insurer to raise the defects during the process preserves that intent. So we would urge the court to say yes, that waiver is available. And in this case, the evidence is very clear that there was a waiver.
Because travelers never raise this. I mean, to follow up to what Judge Northcutt is saying, it's very clear. I mean, it would have been one thing if immediately they say it's unclear. Mm-hmm. Your notice is a bit unclear, right? And the fact that they basically did not do anything, did not raise that issue at all, participated, through the whole process. Just, it just raises, for me, it raises a question. It's like, did they understand it? Did they can't come back now and say, sorry, not quite sure. We were not put on notice of this issue.
Right, Your Honor. And it's not just the response itself, right? The response at page 5395 of the record states, this is what your civil remedy notice is saying, failure to offer UN benefits. It denies all the assertions of improper claims handling. It welcomes the opportunity to respond. It outlines the facts of the accident. It outlines the facts of the claim handling. It states, we just don't think you're that hurt. The damages here don't reach the level of the UN coverage. That was the issue in this case. But we have not only that response that was filed contemporaneously, we also have the claims file. The claims file that says, hey, we got this CRN, we're going to meet about it, we're going to roundtable it. Nothing in there about, we don't know what they're saying, we don't know what the violation is. It's not mentioned in their internal documents. It's not mentioned in the depositions of the claims handler or the manager who supervised the response and the handling of the civil remedies notice. It's not mentioned in her affidavit. Everybody understood exactly what was going on. They responded at the merits. It was not till 9 years later during this lawsuit that the lawyers representing travelers in the bad faith case said, oh, hey, this is super confusing. We don't understand what's going on here. So from that standpoint, and I think this relates not only to the waiver issue, but also to the compliance issue.
And this is what's interesting, Ms. Gunn, because I know there's been a lot of confusion, the way that I see it, and this will give you an opportunity to correct me. Statutory construction and compliance, in my opinion, are two different things. And so strictly construing a statute and then requiring substantial compliance with its requirement, for me, they're not inconsistent. And so you could have substantial compliance, and then it just reading the briefs, and I think a lot of people get confused about those two. So the statute itself, as you read it, nowhere does it say that it requires strict compliance. Instead, it just, you're certainly construing a statute and then requiring substantial compliance with its requirements. So am I reading it correctly? Am I incorrect in that assessment?
You're 100% correct, Your Honor. And that's exactly, it's not just what the courts have said in the Starr case and the Ping Pong case and the cases expressly saying, here's why substantial compliance is the correct test. It's actually the test that's been applied in every case, state or federal, whether you say substantial compliance or not. The test is, did this civil remedy notice give enough information to identify the claim, allow the insurer to understand what you're claiming they did wrong, and allow a meaningful opportunity to cure? If that happened, then there's compliance.
And now we're kind of getting into what the definition is of describe what specificity means. And,
Sure.
and it seems to me that the cases that talk about the kitchen sink approach, and the judge called this one that, and I'm not confident that's accurate, but
Right.
Basically there's a line to be drawn somewhere, because they're complaining that, if you just say, okay, the parts of the sex portions of the policy that were violated, and it just says, see the policy, well, clearly that doesn't comply with the statute. But if you list a bunch of provisions, now you're accused of being making a kitchen sink claim, but what you're doing is providing, I suppose, too much information. Is there a line somewhere that we can find in the law that says, because it seems to me a plaintiff could sincerely believe that this provision of a policy is implicated when it's not. And if they
Sure.
list that provision of the policy, or two or three, do they risk then being told you didn't give enough specificity because you listed too many things?
Right, Your Honor. And that problem would apply to not only the policy language issue, but also the statutory provision issue, right? Those are the two kitchen sink things.
Yes. But
right?
Yeah, right. I'm just using the policy as a
Yeah. And, we would say that the court's analysis in the apostolate case is really helpful in this regard, and also in the Wupshall case, which was a case. And that is basically that it doesn't just have to be a list in that section of the policy. You know, is there a line? Sure. Is 38 statutes like in Julian and Damas too much? But in Apostolic, there were 8 that didn't apply. Here, there's maybe 3 or 4 that don't apply.
And so the next question that I have, because what you're describing is sort of well, I know it when I see it.
Right.
How then do we impose on that overlay the strict construction argument in terms of what is specificity?
Sure, in 2 ways, Your Honor. First, understanding that strict construction comes from the fact that this statute is in derogation of the common law, right? And what did it do in derogation of the common law? It created a remedy. And so broadly, the statute creates the remedy. Narrowly, subsection 3 is where we get into this notice thing, right? And so as the court explained in Pinpon, you can't interpret the notice requirements. So I'm going to use the word strictly, but so as to subsume or do away with the intent of the statute, which is to create the remedy. But again, all of these cases, including the Julian case, including the Damas case, even the concurrence upon which they rely, they say, okay, here's the facts of this case, and here's how this works out, and we're convinced or not convinced that this does substantially comply. There's no case applying strict construction, right? But all of these cases say they're applying the test that we urge the court to adopt and to approve, which is, does it identify the claim? Does the insurance company understand the violation that's being alleged? And does the insurance company have a meaningful opportunity to take advantage of this time period? So within that, in this case, it's pretty easy because we know from the response, the claims file, the depositions, the affidavit, Travelers had no problem whatsoever. So I don't know that you need to define the line in this case so much as you just need to say,
I'm concerned that we don't know where the line is, and yet the argument is this has to be strictly construed, basically against the complainant. I mean, it's unclear. Right. How do you strictly construe the statute when the line isn't identified?
Right, and the courts first, and again, this whole line would come up not only in the policy, the list of the policy provisions, which says if any, right? So is that even really a line? If any, in this case, it was I have coverage, I'm hurt, and more than the tortfeasor's 10 policy, pay me my coverage. There's no real policy provision that's at issue. That might be more applicable in a case, the if any might come into play in a case where there's a coverage dispute about whether someone's insured or something like that, right? Importantly, again, the cases all, whether they say strict compliance, substantial compliance, whether they call it that, whether they're state or federal, are applying the test that we say the court should apply. And the record here reflects that was plainly met. Travelers did have meaningful notice, actual notice, an opportunity to evaluate the alleged violations, an opportunity to cure. They just said, no, thank you. We don't think your case is worth that much. And that's all that happened in this case. And I think it's important to emphasize that it's Travelers' position here to adopt a strict compliance would be the change in the law. We're not proposing a change in the law here. We're just requesting that this court require the trial court to apply the test that's already been applied, regardless of what you call it, throughout all of these cases. It's important, as you said, are we imposing this strict compliance on a complainant? Oftentimes it is. This is meant to be a procedure for an individual insured. You're not meant to have to hire a lawyer to go get your 10 policy under the civil remedies notice. So how much of that are we going to require? I think, this case is pretty straightforward in terms of what the line is. And then the notice is not perfect, right? It has some issues.
You're lucky the statute doesn't say, and I notice it's not sloppy.
We're pretty lucky about that, Your Honor, yes. But, and the fact is, we don't even have a peep in the internal claims file notes about, we don't know what they're talking about here. So, we would ask the court to reverse and to confirm in this district the waiver availability, and also the test, whether you call it substantial compliance or not, to explain the difference between strict construction and substantial compliance. The analysis by Judge Middlebrooks in the rehearing and Ping-Pong 2 or reconsideration. And again, we're not asking the court to do anything new. We're just asking the court to confirm that and to direct the trial court to apply the existing law.
You're right at your rebuttal time, Miss.
Thank you. Unless the court has anything further, I'll reserve.
Okay, thank you.
Thank
Okay. Mr. Appley, you're up.
Good morning. May it please the court. Jack Ryder on behalf of Travelers. I understand in hearing the court's dialogue that waiver is going to be a significant point of this discussion, and I intend to address that head on. But I first think it's important to note that we never even need to get there, because the language of the statute does call for strict compliance. And I want to explain why that matters.
But let me ask you this question, Mr. Ryder.
Yes.
If you say you claim that 5 provisions of the policy are implicated, but only one actually turns out to be, have you strictly complied with the statute, or have you not been, because all the complaints about not being specific enough, none of them involve not giving enough information. They're claiming the notice claimed too much. And some of it is, it's pretty obvious. If you just say, look at the policy, the whole policy, well, obviously that's not being specific. But if you list a lot of things and it turns out that some of them don't apply, does the complainant risk being told they weren't specific enough?
Well, herein lies the concern, Your Honor. And I just want to, so let me answer that question. Is the plaintiff being specific enough? And the answer is no. But I want to say this. First of all, let me start from the premise of, a question was raised, what is this distinction between strict construction and substantial compliance? And I understand that significant point, but I think what we have here and what the court has the benefit of is a clear, unequivocal, and unambiguous legislative intent that compels a strict application of the language, because what it says is shall. And it talks about that. You look at the language of the statute, and it talks about the fact that a person who is providing a CRN has specific duties and obligations when doing so. And it talks about shall identify with specificity the language of and so, Your Honor, the language of the civil remedy notice doesn't have a high bar in terms of what it requires. But it does have a strong admonition to the person who is submitting the civil remedy notice to strictly comply with what is obligated. And, the reason it matters here, Your Honor, is because we have one could say there's a fine line, right? Well, if it's too much information, is it too little information? Identifying with specificity the specific provision of a policy that's been violated, that even if somebody identified more than one, there would still be specificity. I think it matters here, Your Honor, because we have a CRN, a civil remedy notice, that is so flawed, respectfully, that it wouldn't strictly comply by any stretch of one's assessment, and it doesn't even substantially comply. And I think that matters in this context because we are talking about a case-by-case analysis. And when we look at, and by the way, enforcing strict compliance, which is consistent with the language of the statute, avoids the very issue that we're dealing with right now. And that is a debate.
If I may,
Of course,
Mr.
Judge.
So
I'm sorry, Your Honor.
Your position is there's no such thing. All the other cases out there that indicate substantial compliance. And what I've told Ms. Gunn earlier is that in my mind, I don't see them as being inconsistent. That if you're strictly construing the statute and then requiring substantial compliance, I don't think those are inconsistent. So I think what you're trying to have us do is to not follow any of the case law out there in the state and then go directly and say from now on, it has to be strict compliance. Is that what you're asking us to do?
Your Honor, I disagree respectfully. I'm asking this court to accord its conclusion with the way I interpret other districts. When we look at the 4th District's analysis, And this is just on the issue of strict versus substantial compliance. We've cited, obviously, the Julian case from the 4th District and the Damas case from the 5th District. And both of those cases said that they cited Talit, the Florida Supreme Court's decision in Talit, and they talked about the fact that this is a statute that, because it is in derogation of common law, it must be strictly applied. And here's the point. Now, Justice Sasso, it's a concurring opinion, granted, but Justice Sasso brought clarity to this analysis, in my respectfully suggest, because in her concurring opinion, Justice Sasso, in the Damas case, sought to crystallize this exact distinction that Your Honor's honing in on. And Justice Sasso wrote, quote, "Nothing in the text of section 624.155 permits substantial compliance to be considered in determining the legal sufficiency of a CRN. To the contrary, the statute employs the mandatory language shall when specifying both the form and the content of the CRN. The statute further requires that the content be stated with specificity. And if that were not clear enough, the statute then restates that a CRN must state the specific statutory language and the specific policy language relevant to the alleged violation." Justice Sasso, and she obviously at the time she was a judge and now justice, goes on and talks about why the federal cases that have applied this analysis to reach a different assessment and to refer to this as substantial compliance are simply not correct. Now, again, that's a concurring opinion, but I think it clearly informs the decisions, because both Julian and Damas, in those cases, the 4th District and the 5th District, they both used the term substantial compliance in their conclusion, because what they both determined in those cases is that even if we applied this standard of substantial compliance, the civil remedy notices in those cases were not sufficient. But both of those cases explicitly referred to Talit, referred to the notion of strict compliance, talked about the fact that this is in derogation of common law. And that goes back, Your Honor, to the point, when we examine the language of the statute, it informs the application of the assessment. And I understand Your Honor's point. The distinction between strict construction of a statute and substantial compliance with its terms. Justice Sasso, in her assessment and her wisdom in describing this in her concurring opinion, collapsed those two and made
conflated might be a better word.
I'm sorry, Your Honor?
She said conflated might be a better word.
Yeah, conflated.
Your Honor, I mean, certainly, again, it's a concurring opinion, but I think it really does inform the disposition of what the court in those cases assessed. And this goes back, Judge Kuzam, to your point of, am I asking this court to reach a decision that's inconsistent with other districts? I respectfully say no. I'm asking this court to reach a consistent conclusion. And I'll also note this court in its per curiam affirmance in Casella, while not, of course, precedential, I think is persuasive because it cited Julian in its disposition. And
on that topic, Mr. Ryder, I was kind of surprised when I read that provision, that portion of the order, because I've never seen it done before. And I'll tell you, I'm the 3rd most senior appellate judge in this state, including the justices, including Justice Sasso. And I'm reading this order in which the judge is citing the briefs in a PCA. How did that happen? Did the judge go look up the briefs? Was there a request for judicial notice that was litigated at all? He mentioned that waiver and estoppel came up in oral argument. I mean, and he's citing this in the waiver and estoppel portion of the order, and that's not mentioned at all in the citation PCA or in the parenthetical.
And I want to be clear, Your Honor, that I am not relying on Casella in my argument today.
No, but how do we deal with the fact that the judge did?
I think, Your Honor, that what the judge did, and again, per curiam affirmances can have persuasive impact, particularly when they are citation per curiam affirmance. And it's such that the judge can disregard what would otherwise be binding decisions from another DCA? No, Your Honor. But again, this judge did not in any way ignore or depart from binding decisions in another DCA. I have yet to hear a decision that has been cited that is binding and compels a different outcome. And
on waiver,
On
And
waiver,
estoppel, the
yes, Your
fourth
Honor.
DCA holds that you can have waiver, and the judge says, well, yeah, but I'm going
Well,
with whatever, the Caselli or whatever.
okay,
Isn't
so
that what his order says?
well, Your Honor, I mean, again, on a de novo standard, I'm going to refer more to and what I mean by that is that to the extent that the judge reached a decision as to the waiver issue, I want to be clear about this. You know, waiver is an abuse of discretion standard. And I think the question here, the judge didn't just find, go ahead, Your Honor. I see
No.
You're muted.
I'm
can't hear
loading
you,
my
Your Honor.
muzzle loader here, maybe, but I'm not
Oh.
sure I'm going to pull the trigger. So you keep going, Mr. Ryder.
Yes, Your Honor. I understand the court's observations and concerns, and I think this is why I hone in first on the concept of strict compliance. I think it's very significant that we never have to get to the issue of waiver because there was no strict compliance. And quite frankly, even if this court were
Wait, I gotta stop you there, because I'm having trouble with following that. It seems like to me that, okay, you look at this and you decide, okay, well, there wasn't strict compliance. You're saying that can't be waived by the insurance company? They can't waive it. They can't just accept it, enter into negotiations, whatever, proceed as if it was in strict compliance?
My position on that, Your Honor, is that strict compliance means that it is a condition precedent, a statutory prerequisite. And that
But the thing is,
So
like
you're-
even the
yeah,
rules
but-
of the rules of pleading suggest that you can waive a failure of a condition precedent, because they say you allege satisfaction generally, and you have to deny it specifically. And if you don't, you've waived it.
And the reason why I stand on that position as a threshold point, and then I will confront the waiver directly, because I want the court to be clear that I don't believe we waived it, but I want to answer that question first. In Stresscon versus Madeo, the Florida Supreme Court explained, and it talked about waiver, and it talked about the fact that no prejudice has been nor can be shown is not the determining factor in this case, nor is it significant that Stresscon substantially complied with the mechanics lien law. Courts have permitted substantial compliance or adverse effect to be considered in determining the validity of a lien when there are specific statutory exceptions which permit their consideration. What I mean by that is, I believe that Florida law suggests that while you can have waiver as a matter of law generally, that the legislature has to dictate whether or not, based upon the language of its statute, whether or not something is even waivable in the first instance.
Okay,
The
so
statute says
but the statute doesn't say, and it's not waivable. Doesn't say
correct.
that. So what do
It
you
does
do
not.
then
It does
under the
not.
rules of civil procedure when a plaintiff fails to allege alleges generally satisfaction of statutory conditions precedent, and the defendant just generally denies it, and the rules say you have to specifically deny that? How does that play out?
I'm glad that you asked that question, Your Honor.
I knew you would be.
Because it takes us directly into the fact of why there's no waiver here. And so I'll start from the premise of this. There is a distinction between a condition precedent to an act. Okay, here, statute is unequivocal, shall. The complainant shall do the following. So that's clear. Now,
It also says that the department shall specify the ways that the notice is insufficient.
That's true, Your Honor. But
Doesn't anymore, but
it did at some point, yes. And Your Honor, the plaintiff or the complainant has a duty, shall do certain things. Now, once the litigation process begins, and this goes right to the heart of Your Honor's point, rules of civil procedure kick in. At that point, we have implications of waiver, because then you're talking about a different dynamic. You start from the perspective of a statutory requirement, and when you enter the litigation realm, rules of civil procedure kick in. So, for example, in the Neal case, Geico versus Neal, or Neal versus Geico, where the 4th District found a waiver, the 4th District noted that not only was there no reference to the particular defect in that case, which, by the way, the defects were nowhere near as severe as the defects here, but the court also highlighted the fact that in that case, the insurance company didn't raise the defense in their answer.
yeah, but they did not say that both of those conditions have to be present for there to be a waiver. In fact, it said this and in addition that. It didn't say these two things have to coincide.
And it also did not say respectfully, Your Honor, that either one standing alone would have constituted a waiver. And therein lies the point that I'm making. You are correct that once rules of civil procedure kick in, there's a different level of assessment. And what did Travelers do in this case? Raised it as a motion to dismiss, raised it in answer and affirmative defenses.
Yeah, but this goes to, I'm sorry, Judge, but this goes to your argument that you can't waive a statutory condition precedent. And I'm suggesting that somehow the rules of civil procedure don't accommodate that position.
And my response to that, Your Honor, is that we're talking about two different paradigms. There is the statute.
Oh, I understand. But I ask you then, what happens if the plaintiff alleges generally a satisfaction of a statutory condition precedent and the defendant doesn't, and the defendant just issues a general denial? How does that litigation proceed? What happens in that situation?
Oh, so here's where, Your Honor, I will agree with you based upon, I'm going to agree, but gently agree. And here's why. Okay. Well, here's why.
This is kind of like last night in I don't know if you watched the debate, but you know.
I don't know how to respond to that, Your Honor, but I did not get to see it. I was preparing for the argument, so I didn't get to watch it. But in any event, Your Honor, the fourth districts in their decisions, we have Evergreen, we have Bay, we have Neal. In each one of those cases, I will agree that the fourth district drew reference to the potential waiver. I acknowledge that. Okay. But waiver is a fact-specific analysis. Okay. Waiver has to be demonstrated as a known and intentional relinquishment of a right. Waiver has to be assessed under the abuse of discretion standard, which I think is very significant here because there's no demonstration, respectfully, that there was an abuse of discretion here, because based on the totality of circumstances and evidence and facts by Travelers in this case, I think we fall outside to the extent this court concludes that what I consider to be a strict statutory assessment requirement, at least preceding litigation. Once litigation ensues, to the extent that the rules of civil procedure dictate that waiver can occur, and the fact that the fourth district found waiver in those cases, I think is important because this case is so distinguishable because once litigation ensued, Travelers preserved its position immediately, right out the bat. And
okay, I want to just jump in with a question.
Yes, of course.
In your view, because there's a context to all of this. In your view, why is insured required? What is the point of having them do a CRN? Why is that required?
Sure. The point of the CRN is to give the insurance company a meaningful opportunity to understand how it can cure within a set time period.
Okay. How does your argument and what you're proposing that the law should be, how does it serve that interest? How does it promote that? It seems to me it does the opposite. It thwarts it and it sets a gotcha up down the road.
I think the
I
opposite.
want you to respond to that, please. I know you don't agree with me, but tell me where I'm wrong.
Your Honor, I actually agree with the premise of your question because the gotcha here is not by the insurance company. Okay, the gotcha here is by an insured who submits a civil remedy notice that refers to an incorrect policy amount, refers to incorrect violations. And
okay, let me stop you.
Sure.
Because what then prevents the insurance company from saying, I don't know what the heck you're talking about, need more information? I mean, if what we're trying to do is give the insurance company an opportunity to cure, what is wrong with requiring them if they don't understand it? Look, you're being put on notice. You've got this opportunity to say, okay, I don't understand. We need more information.
And when you say what is wrong with that analysis, Your Honor, I would respectfully submit that the legislature did not deem it to be so. I mean, this is a matter of the statute and it dictates a certain obligation. It does not say if the civil remedy notice is defective, the insurer shall respond and identify for the insurer.
No, but I guess if the insurer wants to take the opportunity to cure, it could be in the insurance company's interest to do that.
And, you know,
Otherwise, we could say, well, you waived this opportunity.
Your Honor, you're absolutely right. And the legislature is the authoritative embodiment that is in should, if that's a correction, that's a legislative matter. With respect, it's not a judicial matter. It's not about rewriting the statute to impose obligations on a carrier that don't exist.
Okay,
You know,
Mr. Ryder, we have helped you use up your time, but I want to ask you one question.
Yes, Your Honor.
What do you think the department's role is in this whole realm? I mean, it started off, the department received the notice and the statute, I think, was kind of ambiguous. It said the department may return an insufficient notice, but it must specify what's wrong. But you know, and I think there was a time when the department forwarded the notice to the insurer, although the insurer gets a copy to begin with. And so that whole department can return was eliminated, but the department still gets notice. Why? What do you think that is for?
Your Honor, so the reason for it, I imagine, is to have an administrative body that has some degree of oversight and to have a collection place for.
It's not the Department of Insurance.
Well, in 2019, as Your Honor noted, that the idea of returning it was removed. And
Yes.
I look to the Julian case for the answer to this, Your Honor. And I look to the Julian case because in Julian, the court made note of this, and it talked about the fact that and I apologize if this is not directly answering, you know, what is the purpose, but I guess I'm answering it by identifying that in the Julian case, the 4th District made clear that, number one, the fact that the department did not return this deficient notice was irrelevant to the discussion to the Julian case, number one. Number two, the court noted that even if the department, we don't know what if the department considered it, looked at it, evaluated it, but the court.
We don't know what goes on in that department.
Right. Well, I don't know as it relates specifically to this issue, Your Honor, and I don't know that it's in the record to answer Your Honor's question, but in Julian, the court said that the circuit court should independently review the notice, even if the department had made a specific determination. And so it's up to the circuit court or this court in assessing whether or not it complies, right? On whether it strictly complies with the statute. I know I've used up my time. I hope I've answered Your Honor's questions. Is there another question, Your Honor? No. Then I just say in conclusion, we ask that this court affirm this specific civil remedy notice, again, is so far removed from either strict or substantial compliance. And I respectfully submit that based on Travelers' actions in the litigation, there is no waiver. And I ask this court to affirm in total.
Okay. Thank you, Mr. Ryder.
Thank you.
Ms. Gunn, you're up for rebuttal.
Thank you, Your Honor. Just a few points. I'd like to start by answering your question, Judge Northcutt, about how did we get to the point of relying on a citation PCA. And I would just direct the court to Travelers' motion for summary judgment at page 6109 of the record. 2/3 of that packet is the documents in that PCA case, including.
But there was no motion for there was no motion for judicial notice. And neither was there an objection, I gather. No, none of us were there, but
right, none of us were there. But what I will say is that it's improper to be relying on it as controlling precedents when in the face of these multiple 4 DCA cases. Second, the Julian case.
Ms. Gunn, I know you're in your rebuttal, but one thing that Mr. Ryder said and Judge Northcutt said that I just want you, which still concerns me. Mr. Ryder's taking the position there can never be any waiver of any condition precedent. Well, if you can waive speedy trial in a criminal case when you're dealing with your liberty, how do you reconcile that with this?
I don't, Your Honor. And I think, we've cited for the court the cases not only holding that this particular notice requirement is waivable, but that things like the medical malpractice pre-suit is waivable. Like all of these things are waivable. And again, we get into the issue of, does the statute have to say it's waivable? In none of those cases does the statute say that it's waivable. So there is no way to reconcile that, Your Honor. we would ask this court, one of the things we're asking you to do is to the extent all these fourth DCA cases and the ping pong case aren't enough to convince insurance companies this is waivable and that they're going to waive it by not raising it, that this is a really good case to establish that law in this district, because we very clearly know from the response, from the claims file, from the depositions, that there was no issue in this case about understanding what was going on. So we would ask this court to clarify that. I do want to talk for a minute about the Julian case, because Mr. Ryder has argued again, like he did in his brief, that really all Julian did was just say, like, at a minimum, this doesn't substantially comply. And they cited in support of this argument for strict compliance as a consequence of strict construction. I like the word conflate in that regard, because I think that's exactly what they're doing. But if you go back to the Julian case, the Julian opinion was on rehearing. And one of the reasons they granted rehearing and rewrote their opinion was because Judge Middlebrooks in ping pong reversed himself on this very issue. And the Julian court block quotes this substantial compliance language from the ping pong case. This is not a just haphazard throwaway, oh, at a minimum, it doesn't substantially comply, but we're applying strict compliance. There is no case adopting or applying strict compliance in Florida, state or federal. So again, Traveler's position is the one that would be creating a new law, not our position. On the issue of shall give notice, I think our best case that we rely on is the QBE case from the Florida Supreme Court, in which there was a statutory notice condition in an insurance context. And the statute there said must, it didn't say shall, but equivalent language. Again, it was not in the statute that you have to give any particular type of that substantial compliance was good enough, anything like that. And the court held, yes, substantial compliance is good enough in the QBE case. And like the court in the Apostolic decision, what's good for the goose is good for the gander. If the insurance company can have substantial compliance for their statutory notice requirements that are mandatory, a must, an insured or an insured's lawyer should be able to have that for notice requirement that says shall in the statute. We would ask the court to clarify and confirm the test for compliance with the civil remedy statute, to explain that construction and compliance are two different things, and to reconfirm the application of waiver in this context.
Thank you both very much. Before you go, I'll mention, sometimes doing this work, you see these funny little coincidences. The Casella case, the citation PCA, was decided by two judges from this court, one of whom is sitting on this panel, and they split. And the deciding vote, the tiebreaker, was cast by Judge Stevenson, who was retired from the 4th DCA. So,
wow,
it's funny what you see. Anyway, very well argued. This has been a fun argument, at least from my perspective. I hope you guys had
For me
fun.
too, Your Honor. For me too.
Yeah, I've been there. So anyway, in order to leave our virtual courtroom, you need to click the little leave button on the lower right-hand corner of your Zoom screen. It's either a button that says leave, or it's a pictograph of a person going through a door, and you'll